gave us the answer. But it's not strictly science. And early on, I knew this was an issue. I had a diagram showing this decision tree.
Right.
Remember the decision tree?
Well, and I think because we had a lot of people say, well, you can't reduce natural flow. Well, so you can't reduce it, you can't pump anything. Well, the other side of the statute is we're going to allocate you money to determine how much you can pump. So we're going to have you study it to tell us how much we can pump, which negates the sentence, we don't want you to pump anything. So, yeah, we had that argument a lot.
Oh, yeah, and it really wasn't, I mean, it's clear to me this is not strictly a science question. They wanted to make it a science question because then you don't have to make a decision. You say, well, science says this. And we got all of those hearings and
But the ultimate result was based, I mean, it's not far off. It's based on science. It's
Right.
everybody, there's some wiggle room.
number.
There's a reasonable number that makes it workable based
But
on.
they sure did not want to admit it. I'm sorry, the water board did not want to admit
Well, but
it.
yeah.
Remember that?
Yeah, oh, I do.
They
But
wanted to say it was science.
Well, I need to interject that, the requirement to not reduce the natural flow, that's not a scientific target.
It's not.
And so when you talk about policy, like the policy started the study.
Right.
And so there's a mismatch at the beginning and at the end of the
Absolutely.
study.
Yes.
And so you have to keep that in mind when you're, when the ultimate decision was made. And so I just wanted to point,
Oh, yeah, I know.
just point
From
that
the
out.
science point of view, it was really, it's like, I knew from the beginning that it could not be strictly science. And early on, I made a little decision tree showing, science is one limb, but there's policy and there's laws and there's, different parts of this decision. Just trying to get across the point that,
it has to be workable. The policies have to be workable or they're not going to hold up. That was our concern, was if the science went to you can pump a bucket of water, and everybody's been pumping 2 buckets of water, we would have a major issue.
So it's really coming down to that target, which was not defined.
Yeah.
Yeah.
And ultimately the 25% reduction.
And what we did was in the report, modeling report, we just we did a graph, it had line that went up for the Blue River base flow and Pennington Creek base flow, and then also total surface flow. And then you could say, okay, well, we could do equal proportionate, pumping all across the aquifer. If you pump this is much, this is what, follow the line, this is what kind of reduction you're going to have on Blue River or Pennington Creek, or, what kind of flow are you even talking about? How are you going to measure that? So that was how we resolved that. Here's the information, you figure out where you want to draw that line and how much you can.
Because I remember being I don't know if you were on the conference call with Peter Fahmy and a bunch of us, and they kept wanting to go back to, I can't remember what the number, there was a really low number being put. I said, guys, that will not work. That will not hold up. There's no way we can get that through. And finally got them to understand, I get that we want it to be totally based on that, but the science isn't going to matter if the policy falls apart and it goes, out the window. So, yeah. On a lot of those conference calls, but I didn't know if you were on that one or not.
No, I wasn't involved.
Having those hard
I was not
conversations.
involved with the policy calls. So. Anyway, it all worked out. So. And I don't, in terms of implementation and things like that, I really haven't been involved with any of that. So that's where I'm going to stop.
We'll hold our questions until the end, because I know you guys have some. I see it in your faces.
Yeah.
So let's hold it until the end, and then we'll open it up for everybody.
Policy, that's kind of what back when 288 got passed, I wasn't there in the initial days of the writing of 288. I understand there was a lot of wrangling over that, but my first policy advocacy was on 288, and I walked into that building. I didn't know anything about the Arbuckle Simpson, barely knew where it was, knew nothing about hydrology, nothing about anything other than I needed to protect my water. That's all I knew. And walked in there with a great group of people. Several hundred of us flooded the Capitol when we were passing that bill. Got it passed, got it done, and then the hard work started. I mean, it's passing the statute is nothing compared to getting it ultimately where it's like a pregnancy, you know, really good fun at the end, then you got a lot of misery in the middle, and then at the end you get the baby. And that's kind of where we were. We had a lot of morning sickness at the beginning, I can tell you. It was, you know, the determination of the number. We were able to kind of sit back for a while. And interestingly enough, so the study gets done, and we're waiting for it to be signed off by the USGS.
Well,
The
the final paper.
Yeah, you know, so that it could then go to the water board. So I'm in Atlanta speaking at a conference on how to get agencies to engage stakeholders. And I'm sitting around, I think I had a scotch and a cigar, and I'm talking to this woman who was her name was Dixie. Remember Dixie?
Mm-hmm.
Her name was Dixie, and she was like the overseer of this department. And so we started talking about 288. She goes, I think I have a study of that on my desk. And I said, I need you to get that off your desk. I need you to get that off your desk, because it's been sitting there a while. Because we were all waiting. We were all waiting. So we drank some more, we talked some more, and sure enough, within like 2 months, Dixie has signed it out. So scotch and cigars, let me tell you, got that thing moving, because we were afraid that it was going to sit up there and get caught in some sort of a political football and not be stamped, ready to go, so it would go to the Water Resources Board.
It was really expensive scotch.
It was well worth it. So got that thing moving, and then we had to sit around and figure out, okay, so now we have 288, we have the science, we have the number, now what? Now what do we do with that? Because when you're doing policy, it's not just the statute, then you have the rules. Then you got to deal with the rules that govern that statute. The statutes are usually very broad, and the rules are where the meat is. The rules are how you're going to do what the statute requires. And so there was a lot of concern about what that would look like. And, you know, as a collective group, our organization has spent years building relationships and coalitions and trying to really educate people on water. Because most people are like me. I mean, the idea of tell me about your water sources, well, I'll go turn the sink on for you. With really no in-depth knowledge. And I would tell you that most people in South Central Oklahoma know more about their water source than any place else in the state. They know more about it here than they do any place else. And I think we take some credit for that. You know, we can, as a group, we can bring the knives and the pitchforks, but we're also very good at, we kind of moved away from that knives and pitchforks group into more of a trying to work with folks to work out the issues, and because we all live here, and, you know, kind of more that coalition building. We held, we have big meetings, we have hundreds of people come before the maximum annual yield, when it was determined. We had a big meeting here in Ada. Lots of people came, and it was, you know, this is what the agencies are doing. I think you were there. Water Resources Board were there, because I think that one thing that agencies have a real challenge, and it's not necessarily because it's their fault, it's a lot of it's staffing, and a lot of it is not having the understanding of the necessity of, but engaging with stakeholders is critical. And we were the stakeholders. We were the people that were ultimately going to be affected by the decisions that were made by the agency. We worked hard to pass the law, so now we had to deal with the agency. We had changes of heads of the agency. Got an argument with those agency heads, and I was okay with that. We were in there fighting for what we knew we needed to fight for, because at the end of the day, most of these folks that work in these agencies, nothing against you, Jonathan, at all, but they live up in Oklahoma City. They live in the area where their offices are. They don't live down here, so it's incumbent upon us to make sure that they know how their decision is going to affect us. And if they don't truly understand that, that's our fault. It's because we've not made the effort, and it's a huge effort. It is a huge commitment to make sure that agencies understand these issues. And we built a pretty good coalition to bring people in there to do that. So we get to the rules making process. We get the Max Manual done, and then it sits in court. And then we go through the rules. Am I getting that right, the timeline? Okay. So we get there. We were so excited to get the Max Manual determination to pass by the board, because we started labor pains now. We're so excited that baby's going to be there. And it was just, it was a moment for us that we had fought for over a decade for. And that meant a lot to us. So that we knew there was going to be a suit filed. We knew it was coming. Can I tell them about your phone call about dropping the suit?
We try to do some legal.
Okay, so
wrangling.
Christina, we decided, because we were trying to figure out what district it was going to be in. So Christina is on the phone with another attorney the moment it is approved. Do you know this story? Okay, so the moment,
I came along after.
I have a picture
I'm really
of
excited about the story.
of Christina, and we're in this big room at the Norman Embassy Suites, and it's packed full of people, and the board, there were some members of the board that didn't like the policy, but voted because it was the law, which is what you should do as a board member. So they voted for something that they didn't really love, so we were a little nervous about whether they would do that. So Christina's in the corner, because we've got this pre-planned. So Christina's in the corner, and as soon as it's voted, as soon as we get the majority and it's voted, I think you said, go ahead and file. So we file a suit in Johnston County, Pontotoc County, regarding just a question before the court about some issue in the order. So that if we could, we were going to wrangle the suit that we knew the other group was going to file into Pontotoc County. That was our move. I've got a
We
picture.
knew it was a long shot.
We knew it was a really long shot, but we do a lot of those. And Christine's in the corner, and she's like literally going, fight. And I mean, the moment we hit majority. And so didn't go anywhere. The other side, and that's Farm Bureau et al., filed the suit. And from that point forward, it's been a legal policy fight unlike I've ever been in. The legal stuff Christina's got, I mean, she is on it. And if you've never read one of her briefs, you need to do it, because they're really good. They're exceptionally good. She'll call me and she'll say, is it okay if I call them this, my brief? I'm like, sure. And I know she's just free thinking, and it's probably in there someplace, and then she goes and she takes it all out and makes it all nice. But if you've never had the opportunity to read a brief, read it. Even if you're not planning to go to law school, read the briefs, because they're so well written, and they're written they're written on a level that the non-attorneys can understand. And it just lays everything out so beautifully. So she's got the legal stuff, and I'm meanwhile trying to keep the policy stuff together, because the thing about a statute is it's a statute that can be changed, and it can be changed very easily. And so CPASA is this, we have benefited greatly from being underestimated every step of the way. We go against some really big interests, and we are underestimated. And so far we have won everything that we fought for, and that's to keep the water protected. Mainly we win, I think, because we've got a really good argument. I mean, we have Farm Bureau doesn't like the science. Okay, Farm Bureau give us some work. We'll include it. Well, Farm Bureau doesn't have anything else. They just have the argument that they don't like it. I mean, I'm not even going to go down the road of how nasty they have been, but when we went through the rules making process of what those rules are going to look like, so that folks like you and I that live in the aquifer can pump water but not harm it, well setbacks, time to implementations, because you have municipalities who have a different weight on them when they've got to supply 30,000 people than the guy that is over here has to supply 4 cows. I mean, they're different. They both are valid, but they're different. And so we knew the municipalities were going to have they had a bigger challenge because they had their equal proportionate share. They were going to have to do a lot more water rights. So we went in with an implementation. I mean, we thought this out. We met with people, we talked to people, we talked to stakeholders. I mean, let's look at an implementation period for if you're going to pump over this. And ultimately, you know, I think the rules came out okay. You know, we some of the things we wanted, we got in there. It's a challenge, and it's policy. Just because you write it down on a piece of paper, you think it's good. Policy and getting it done is all about relationships with the people that you're able to pick up the phone and call. If people only see you when you're complaining, they don't want to see you. They want to build relationships with you because, quite frankly, if you've got a legislator or a policymaker on any level, then they don't know you, then they don't know whether what you're telling them is accurate. And so we have prided ourselves over the course of the last, you know, decade and a half. We may not have all the information, but what we give you and what we will ultimately, you know, if you have a question I can't answer, I'm going to find you the information. It's always accurate. It's always truthful, because that's what we have to fall back on. People trust us. So now we become the people that people go to. Tell us about this, or you better go over there and talk to that girl over there in the corner because she's going to get really mad if you're doing something to harm the Arbuckle Simpson. There was an idea that we had this grand conspiracy to take the conjunctive management statewide, that we were going to have this big statewide initiative, and somehow we were going to wait over a decade to pull that trigger. Have no idea where that came from. Totally false, completely made up. But policy it's fun, but it's a different animal. And the science is the one thing that we go back on to is we got the science. You guys don't. We've got the science. You guys don't. It may not be the science that ultimately said you can only pump this much, and we really needed to pump this much. But we've got the science, and that if it weren't for the science, 288 wouldn't have held together. We would not have been able to do what we do. I would argue that 288 wouldn't have held together had we not been there to continue to baby this thing along to where we ultimately have this beautiful new child that hopefully the Supreme Court will say you get to take home.
Grant custody.
Grant custody, full custody.
All right, well, I guess I'm next, if we're going from the left.
Going down the line.
Yeah, right. Well, this has been really interesting to hear. As I said, I'm the latecomer to this party. 10 years late. I joined the Water Board in 2014 in the middle of their district court lawsuit. That was filed after they got the maximum annual yield approved by the board. I'm not going to talk a whole lot about things that Amy and Noelle have talked about, but I wanted to mention, with regards to the law that was passed, Senate Bill 288, and what's natural flow. The Water Board, we do these type of hydrologic studies for all the aquifers in the state. We're working our way through each one in the state. We've done a number of them. We're working on 2 or 3, like at the moment. The traditional way that we do those is we look at like the boundaries of the aquifer, where the fresh water is and where it becomes salty. The boundaries from left to right, so to speak, from east to west and north to south. We look at how deep the fresh water goes and where the water table starts. We try to get an idea of what the quantity of water is. We look at how fast that water recharges from rainfall or other sources, or the river leaching into the soil, things like that. We look at how far, springs and streams and pumping and all the discharges from that aquifer too. And so we really kind of have this water budget and that's our traditional way to look at aquifers. And we have, what we'll do is once we find like what's the size of the aquifer and how much water is going into it over the next 20 years, we decide a number of what is the maximum amount of water per year that can be withdrawn from this aquifer without depleting it within its lifespan. And we give it a
20 years.
a minimum 20 years. Some aquifers in the state have more than 20 years, but the statute says we have to give it a minimum 20 years. And that minimum 20 years is actually longer than you think, because if every single person put a pump on their property over the aquifer and pumped their maximum amount allowable, if they all got permits and they all pumped the maximum allowable, our calculations say that aquifer would continue to exist and it's, to be available for use for 20 years. But in reality, it's more like 10% of that quantity of water is really ever used from most aquifers. And so in reality, the aquifer is going to last much, much, much longer. But that was the scheme that was that was worked into the statutes in the 70s. The big change with Senate Bill 288 is it added another thing we have to look at, which is the springs and streams that emanate from that groundwater aquifer. That turned out to be the one variable that controlled what that maximum annual yield was. The reason is because all the other aquifers in Oklahoma, it's legally recognized that over time the water table is going to drop, and everyone has the same right to use that water. In Oklahoma, groundwater is considered private property, and unless you've sold your water rights to someone else and you own land, you probably own groundwater. And you have the same right to use your groundwater as your neighbor has the right to use the groundwater under his or her land. And what that means is that when both of you use your groundwater, the groundwater table is going to eventually go down. Now, there's also recharge to that aquifer too, but in general, the law allows for the groundwater table to gradually drop over many decades. And it's designed to make that happen fairly and evenly so that all the people living over the aquifer have the same opportunity to use that groundwater. The difference with the Arbuckle-Simpson is that because the springs and streams have to be protected, that turns out to make it almost impossible for the aquifer to be lowered. The water table has to stay at the same level, because otherwise the springs or streams will completely dry up. And so that completely changed the focus of our hydrologic study compared to all the other studies. Noel did a really good job of talking about how many different things they looked at, because when the water board needed to know how not to reduce the natural flow, they really needed to know what's the natural flow, what does that mean? Because if you've lived by a river, you know that sometimes the river's really full, and then sometimes it's really low, and that sometimes that doesn't have anything to do with necessarily what happening on your neighbor's property or anything like that. It mostly has to do with rainfall. It has to do with drought conditions over many years. All of those things matter, and so in order for us to know how not to reduce what's natural, we have to understand the natural state of the Arbuckle-Simpson springs and streams as they exist and as they've existed for many decades. Because if we don't know what it looks like naturally, then we don't know what we're aiming to protect. So that was a huge problem. That's why we had to do this exhaustive study. I say we, it wasn't me. like.
Same. We're all in this
Ms.
together.
Osborne and C. Pasta and Mr. Roos,
We're all in this
they all participated. I came along later and took all the credit. No, I say we because I work for the water board and I really strongly identify with the state and their efforts here.
We're all citizens of the state, okay, with that, so.
That's absolutely true.
We're all in it together.
Absolutely true. But, yeah, I mean, that was their effort, and that's why this one was so different. This is the first time in Oklahoma that we have specifically recognized that there is a connection. I mean, we know scientifically that groundwater and surface water, which I say surface water, I mean lakes and rivers, we know that the water goes back and forth between rivers and groundwater into rivers. We've known that for since the 1800s. But in Oklahoma, because one of them is private property and the other is public property, we have kind of had an imaginary fence there. And we've pretended for over 100 years that there's no interaction until Senate Bill 288. And we finally recognize, at least in one place, that we have to recognize that this groundwater will eventually become stream water, and in some places, that stream water will go back into the ground and become groundwater again. And we've recognized the interconnectivity between those two bodies of water. So that was a huge legal difference that the attorneys had to really wrangle with and explain and reconcile with 100 years of what Oklahoma has decided its law is over its young statehood. So when when the scientists were done and they made their recommendation to the water board, which was going from oh, you didn't? No. Okay. Well, there was a tentative maximum annual yield.
The water board made that
Yeah,
recommendation.
the water board made that recommendation based on the.
What they wanted and what would work.
That's true. This was, and Noelle she is accurate. I'm not disagreeing with her that this isn't entirely based on science, but it is the most informed by science decision on these aquifers that I think that we can agree on.
Yes.
It's the most scientific decision that the water board has made with regard to these aquifers. And we really focused in on what was going to matter the most, where the rubber meets the road, what do we have to see, and what do we have to prevent in order to protect all these uses of the water, both from the groundwater all the way to the cities that get their water out of the river for drinking water, for the people that live within the city limits. And the way the water board process works is the staff will make a tentative maximum annual yield recommendation. They'll say, this is what we think the maximum annual yield should be. And it worked out to be 0.2 acre feet of water for each acre overlying the basin. That was the EPS, or equal proportionate share, that was recommended to the board for approval. And the way that it works is the board would hear that, approve the tentative, and that's when the legal fighting started. That was like that was the gun at the beginning of the race to okay, start fighting. So because before all that, the staff took all the scientific papers and all the measurements, and they put them on their website and made them available to the public and made presentations and said, okay, here's our work, now come after us. This that's a tough thing to say, but that was really the point of this process. And this is an open hearing process that is in the style of a court proceeding. You'll have parties with attorneys, and they will sit scientists up there in the witness chair, and they will ask them questions. Scientists and government officials.
Yeah, blacked out during that time.
I listened to a lot of Miss Osborne's voice before I've ever met her, because I was listening to that testimony years later. But it's a court-style proceeding, and first the water board has to explain how they came to their opinion, their recommendation, and then the other sides get to put on their criticisms of that. And every witness that gets up and would explain what they did and what their involvement was and what their recommendation was had to be examined by every other party's attorney. And so that was, you can imagine, some people were in the witness chair for a long time, and they got pretty beat up, some of them.
And they had a lot of high-powered attorneys.
And they did, they did.
The other side.
It was
Yes, good attorneys.
it was a,
Nice.
well, I mean, you've got a high-powered attorney
Oh, I'm
too.
saying that, but we're nice.
Okay. But that was, I mean, that was a long process. It was, we had to, we ordinarily would have one of our staff attorneys do hearings. I serve as a hearing examiner for some water permit cases. But for this one, we knew it was going to be very public, it was going to be very highly scrutinized, and so the water board went out and hired a lady who was currently, at the time, she was an OU law professor, and who had an engineering background, an energy, natural resources, educational background before she became a lawyer and a professor. And her name was Emily Mizell, and she became she was kind of like someone we hired to hold our hearing. And so she became the hearing examiner, and I think the hearing lasted, 3 days? Is that right?
It was at least 2 like 10-hour days.
Oh, that's right, that's right.
We went late every both days.
And I believe it was down here, right? They held that
It was
hearing?
in Sulphur.
In Sulphur.
Sulphur.
In Sulphur. So a requirement by law is that we have to have these public hearings in the area of the basin. So that was, and Sulphur is right in the middle of the Arbuckle Central. So that is where we were required to have it. You know, lots of people attended. I could tell, I wasn't there, but lots of people attended. Even after all the evidence was taken in, you know, there were thousands and thousands of pages of evidence, hours and hours of witness testimony that this professor that had to go through and make her analysis and ultimately conclude either for or against the water board's recommendation for a maximum annual yield. And in doing so, like she ultimately did recommend that the recommended 0.2 EPS be approved by the water board. But one of the main duties of a government agency when they make their decisions, we're given a lot of power by the legislature and sometimes by the Constitution, depending on what agency. But one of the things that we are most responsible for, besides doing good science, is we have to explain ourselves. We have to show our work. When you work for a government agency, you do not have the right to be arbitrary. You don't have the right to say, because I said so. That is, if you try to make a decision and tell someone like, well, no, I'm not going to give you a permit. No, I'm not going to agree with your argument there, and don't explain why, that's the fastest way to get overruled by an appeals court. So that is one duty that the water board was really careful about, and I appreciate that. In when they approved this maximum annual yield, there was many pages of explanation for why this was okay, why this storage coefficient that the water board's people used and the USGS recommended, why was that okay versus this storage coefficient that Farm Bureau's experts said would be a better storage coefficient. And these are really technical disputes between very intelligent, very educated people, and that's a difficult thing for a judge or attorney or anyone to try to sort out. Luckily, we had someone who had a lot of background in that area. And she had the benefit of a lot of scientific testimony that she could listen to acquaint herself with the issues. But ultimately, you know, it's the agency's responsibility to show their work, to be able to explain themselves. Almost, I would say it's more important even than trying to be right or wrong, because everyone thinks they're right. But if you show your work, that's how you show that you're being honest. That's how you show that you're not trying to, there's nothing shady going on behind the scenes. You have to explain how you arrived at your end result. It takes a long time. It was expensive for all the parties, and a lot of these disputes can be. But I think in the end it's worth it, because that's when the public really gets to see, you know, what you're doing with all their tax dollars. What have you been doing all this time? What have you been doing for 10 years? And is this really politically motivated decision-making, or is it really influenced and informed by science like you claim it is? And so that was our responsibility, to put this maximum annual yield recommendation and allow it to be criticized, allow it to be picked apart. And then if it withstood that, then we were able to take it to the board for a final decision on it. And ultimately, in 2013, that's when they approved the final recommendation, and then began the implementation process. One of the findings in the maximum annual yield order was that there could be, that even if we picked an appropriate number for the EPS, even if we picked the right acre feet per acre, Senate Bill 288 still needed some more protection in the form of buffer zones around these sensitive springs and streams, because Oklahoma law allows you to take, if you own land over an aquifer, the law won't tell you necessarily where you have to take that water. If you own a couple acres in, if you own a couple acres over here in Section 5, and then 2 more acres over in Section 32, and those both overlie the same aquifer, you can just put a well in one of those pieces of land and take out the whole amount of water for both, that you get credit for all the acres that you own. The problem, and that's always been the law in Oklahoma, but the problem with that is if someone put that right next to the Blue River, or if somebody owned a bunch of land and put their well right next to a spring that fed, I don't know, just like down in Sulphur here by Little Niagara. Like if someone put a
Bird's Mill,
a big,
David.
or a big well right next to one of these springs, it would completely reduce the natural flow. It would interfere and degrade with that spring or stream. And that's exactly what Senate Bill 288 told the water board not to allow to happen. And so we recognize, that's great that we picked this number, but we've also got to make sure that we have these areas where we're going to make sure that there's not, water can still be withdrawn in those areas, but not concentrated huge amounts of water that are going to affect that spring or stream. So we worked out, and that was part of the rulemaking process, making these buffer zones around these. One of the things we did once the maximum annual yield was passed is all these people who had held permits, at the time they were considered temporary permits, and they were allowed to take, for each acre of land they owned, they were allowed to take 2 acre-feet of water per year, times how many acres they had. Now, we replaced those with regular permits. And the regular permits, they were allowed to take 0.2 acre-feet per year. And so many people, many landowners really thought that was, it certainly did impact them, and they were very upset. The main argument of the Farm Bureau, which was one of our opponents in the appeal, was that we had reduced the amount of water they're allowed to use by 90%, from 2.0 acre-feet per acre to 0.2 acre-feet per acre. And by doing that, we had taken 90% of their water, and since that's their private property, that the government, the water board, had taken their property without compensating them. And we all know that the Constitution guarantees that if the government can take your property by eminent domain or any other way, they have to fairly compensate you for that. And so that was a real problem for us legally. That was a problem we had to address. And what we did explain was that, that temporary permit didn't give you a right to 2 acre-feet per acre for the rest of your life. That was never what that was intended to do. Everybody who lives over an aquifer at some point has a temporary permit and then gets a regular permit. and those amounts are different. And also, we pointed out, and this was a really important argument, I think, in the appeals process, to say, look, the water under your property is still there. Like, we're not taking it, we're not allowing it to be withdrawn by anybody else. We're not converting it to public property by just reducing the amount that you're allowed to take each year. All we're doing is trying to make sure that all the landowners over the aquifer have the same right to use that water and have the same benefit, and that water will continue to be there for the entire life of the aquifer. Senate Bill 288 made clear that we also had to protect some of the surface water users, because those aquifers discharge into rivers. Those rivers were used for many different things, for cattle, for domestic use, for recreational use, for, cities would treat that water and then send it to their citizens as drinking water. So we had to protect those too. And so, that was one important argument we had to make, is like, we are not taking your property. All we're doing is in our power as the state. We have always been given the power through the Constitution to regulate the use of property to protect the health and safety and promote the economy of the state. And that's exactly what Senate Bill 288 says it's intended to do. It's to protect health and safety. And how does it do that? Well, if all the water, if the groundwater, which is the source of drinking water in this area, the main source of drinking water, if that disappears, there's no alternate source. And so all the people here will be, in all the cities and towns and the rural water districts, they will have no other source of water. So we protect health and safety by making sure that source of water will continue to exist and will continue to be high quality water. And then we also promote the local economy, because one of the major economic industries in this part of the state is tourism and recreation. And that's a big, we protect that by protecting the flora and fauna, the water quality in the creeks. If the water gets too low, like you've seen this during a drought, sometimes DEQ will post a warning and say, don't swim in this area, there's been an algae outbreak. And a lot of those happen as a result of the water getting really low, and that allows those bacteria and algae to basically have algal blooms and multiply rapidly to levels that are toxic to people. So those are all the ways that Senate Bill 288 protects those things. And so we had to present that to the court and make the court understand, we're not doing this to take anyone's property. We're doing this to protect the health and safety of everyone, not just the ranchers, not just the cities, not just the fishermen. We're trying to protect everyone. And so far, that's been upheld. Another thing we did during the implementation process, besides making buffer zones, and those buffer zones, just quickly, we have for springs that flow at least 50 gallons per minute, we have a 1/4 mile buffer zone, which means there can't be any new wells within a 1/4 mile of those springs. And for springs that flow 500 gallons per minute, we say no new wells within 2 miles of that area. And so in order to do that, we had to have USGS do a survey and give us a list of every single spring that flowed more than 50 gallons per minute and more than 500 gallons per minute, so that we could put that and identify that in our rules and say, if you're in this area, you can't put a new well here unless you come to us first and get a variance. Also, we protect stream segments, because I talk water goes from the stream to the groundwater and back. We also have a 1 mile buffer from streams that are big enough to flow at least 500 gallons per minute. So this doesn't prevent someone from getting a permit if they live by a stream. We have exceptions, but those exceptions are only for people who have property that are entirely within our buffer zone and they have no choice but to take from their own property. And they have to prove to us that their use of water won't reduce the base flow from those springs and streams by more than 25%. So we do have exceptions for those people who are stuck next to one of these springs or streams that we're coming from. Okay, I'm going a little long, so I'm gonna hurry up. But I told you I came in on the appeal. Some of the things that the parties who are attacking this maximum annual yield order legally have focused on are they want to focus on how the water board interpreted the evidence that was in the record. Now we've got Amy talked about how we had the science and the other side didn't. You know, they did have experts and witnesses that talked for hours and hours and submitted reports.
But
all
never
about-
read the full, did you listen, did you hear that part? They never read the.
That's
they
right.
Never read everything.
That's right. They didn't
took snippets of it.
They didn't submit any of their own scientific reports, but they did criticize the ones that were there. And so that's really what they focused on first was they said, well, you interpreted this information incorrectly and you have kind of fudged it the way you want. And so we've had to kind of combat that. And I really appreciate witnesses like Noel and all those scientists who prepared papers. I tried to reach out to them by telephone many years later to try to understand what they were talking about and what they said in their reports and what it meant and what math they used to calculate the results. I mean, all this mattered in front of the judge. Like I had to find a way to explain this to the judge. And I was really grateful that they all did really good work. Like when I said that the government has to show their work, they all did it. And it made my job so much easier to go through and explain. And I could point to the very page where it said, you know, that, well, no, we chose this because of this reason. And the math works out. And we showed that this stream was related to this stream and that this measurement of flow was comparable to this measure of flow. And we were able to lead the judge through page by page how the water board came up with its tentative recommendation. And Noel, also I want to address the number 0.2, we didn't have any studies that said 0.2 acre per acre is the answer. But what we did have is we had a model that showed us this is what happens if we do 0.125 and this is what happens if we do 0.4. And so we had a number of different options we could look at. And one thing that scientists know, and maybe us that aren't scientists forget, is that every time you take a measurement, every time you do a calculation, there's a little bit of uncertainty associated with that. If you have a thermometer that only reads like to 1 degree, like it won't tell you the difference between 91 or 92, let's say it's a digital one or something, there's a little uncertainty related to that. And when you do calculations and studies, that uncertainty is always part of the process. And scientists are very good about identifying that uncertainty and making sure they follow how much uncertainty exists throughout their study, because that's just part of the scientific peer review process. It's just part of good science. You come up with a number answer, they want to know how accurate plus or minus that number is. And so they did a really good job of that. But one thing that uncertainty allowed the water board to do is to say, okay, look, we've got these numbers from the modeling study. We know there's some uncertainty, and also we know that we are under conflicting policy demands from the law. We have to allow people to take groundwater. We have to. And we have to protect the springs and streams. And so that uncertainty allowed the water board to say, okay, we are going to look at these recommendations. We are going to lean on the side of benefiting landowners who are using groundwater. When there's doubt, if there's any uncertainty, we're going to use that uncertainty to favor the side of people who have own groundwater and want to use it. And that allowed us to reach that 0.2 number. And so that was something we argued so far in the appeal, and hopefully I think the district court certainly saw our point of view on that.